is Maurice Crespi. I'm the managing partner of Schindler's Attorneys. I'll be presenting today. I'm joined with my panelists, Ian Fleming from Engaged Business Turnaround, Peter Gordon from Engaged Business Turnaround, Derek from IQ Business Group, Francois from Business Group, and Artisha from the IQ Business Group. The idea today is not to go through the legislation section by section and give essentially an academic explanation of what business rescue is about. Today is about a practical analysis of the business rescue with specific emphasis on the current situation with COVID. It would be quite easy for us to pre-record these videos and just play them at 10 o'clock each day. The reason we don't is because we want to engage with our audience. So please, if you can, post questions, make this worthwhile for us. We'd hate for there to be no questions because, as I said, this could quite easily have been pre-recorded and we could just play it each day. So the questions can be asked anonymously. You ask absolutely anything and try and make it specific to your industry. I'm going to kick off just by dealing with business rescue in general. I'll be asking Peter to take us through that. But before I do, it's very important for the audience to appreciate that COBRA is not about business rescue. Whilst we have business rescue practitioners who are extremely competent, the idea is to not go into business rescue and to not go into liquidation. The idea with COBRA is to have debtors come into the ecosystem to allow the COBRA mediators to deal with the debtors' creditors, try and bring those creditors into the ecosystem because chances are they also have problems and they have debtors, hence the downward pressure. So if we're able to get all debtors and creditors in a cascading type relationship into COBRA, ultimately all we'll be dealing with are the banks because we'll be able to strike arrangements all the way up from essentially the spaza shop up to the bank. So that's the idea. When we talk about business rescue, duties arise, the law kicks in, business rescue practitioners are officer of the court, and that would come into effect only as a last resort. You're going to hear a lot about the moratorium, which is key to business rescue. The moratorium is a suspension of any claims against the company. The moratorium does not allow a creditor to sue. There are certain circumstances where a creditor can, but the moratorium in essence levels the playing fields when it comes to a negotiation. So be mindful of that. That's business rescue in the present climate is really only there for in the circumstances where a creditor gets pushy and starts saying, well, I'm going to sue, I can liquidate you, I can do X, Y, and Z, being unreasonable, not appreciating that this is an act of God. It's a no-fault situation. Only in those circumstances do you hit the business rescue button, level the playing fields, and the negotiations ensue. So over to you, Peter.
Maurice, thank you. Morning, everybody. Business rescue, Chapter 6 of the Companies Act, promulgated in 2011 of the 2008 Companies Act. As Maurice correctly says, it provides you with a steel blanket around the entire company. Nobody can take legal action. As Maurice said, all obligations are suspended. And it's important to note that that's not only obligations to pay people, that's any legal action that was pending or about to be taken or can be taken against the company. During the period of business rescue, nobody can do that. So what it does is it allows the company the luxury and the freedom to attempt to operate out of the current financial distress that it finds itself in. Financial distress is defined in the Act as the company's unable to pay its debts as and when they're full due in the next 6 months, or within the next 6 months, the company believes it will be technically insolvent. That is, assets will be less than liabilities fairly valued. So if it meets those criteria, very simple process. The directors have to take a resolution. A majority have to approve that the company goes into rescue. That resolution, together with an affidavit signed by the directors en masse or one of their members appointed so to do, files an affidavit at Companies Act, sub C, stating broadly the reasons for the rescue, and most importantly, why the board believes that the company can trade out of its current malaise. If that's in existence, if then all a time-driven process, business rescue practitioner is appointed, or practitioners, you can appoint joint practitioners, who then take on the role of supervisory capacity over the board. They come in as an appointee of the courts. They obviously have to stick to the rules of engagement as laid out in the Act. Important point, Maurice talked about a creditor having the ability to oppose a rescue application, and one of those is a very simple matter that the rescue practitioner didn't file the right documentation or advise Companies House in time and the creditors in time. Miss one of those dates and you're opening yourself up for challenge for the appointment or for the election to go into business rescue. The practitioner then is aiming for two different routes. Either he obviously wants to rescue the company, that is the fundamental aim of rescue the company, and at the end of it, hand back a financially stable and solvent company to the shareholders, back to the directors to run as previously done. The alternative, if that's not possible, and this is often the case, the practitioner is allowed to do what we call a wind down, a formal wind down of the business in rescue, because what you're trying to do at any step of the way is to beat a liquidation dividend, not a particularly high bar to exceed. As we all know, liquidation dividends tend to be rock bottom, especially for the unsecured creditors. And if you can beat that and pay out the creditors during this process, whatever is available from a structured sale rather than a forced fire sale of assets, you should be able to do better than a liquidation. The rescue practitioner is obligated to investigate the affairs of the business. If he finds anything's been done that is illegal, he's obligated to request management to desist from doing so and to report it to the relevant authorities. He doesn't have full investigative and summonsing capacity that a liquidator has, but obviously the goal here is very different. A liquidator is obligated to sell the assets as quickly as possible and pay everybody whatever he can get for those assets, whereas a practitioner is trying to put everything on hold in order to pay everybody a better dividend. The important thing on a rescue is there must be post-commencement finance. It's a fairly hot topic at the moment. SAA the practitioners have failed at this stage to raise post-commencement finance with the government's refusal to put further monies into SAA. And if what we call PCF, post-commencement finance, isn't available, then it's obviously impossible for the company to be rescued. So it is a part of the industry that we spend quite a lot of time paying attention to find appropriate funding. Normally the banks, we remain very close to the banks because the banks, strange as it may seem, are prepared to continue to fund companies in rescue if they believe in the rescue and most importantly believe in the rescue practitioners themselves. So it is important for us, Ian and I, to keep a very close relationship with the particular units in the banks. Maurice, I mean, that's it. Over a sort of umbrella view. I don't know if there's anything I've missed there that is...
No, that's great. Ian, practically, you get appointed or you're approached in these circumstances. We've been approached countless times over the last 3 weeks. Practically, what happens?
So Maurice, the first thing we do is we set up a meeting with a client. In this case, a Zoom conference during COVID-19. And we find out from them what they believe the reasons for distress are. We just get a good background from them during that meeting as to the background of the company and how it was trading before financial distress occurred, and what the reasons for distress are, and how they believe those reasons for distress can be remedied, and how they believe the company can potentially get back on track. And then we ask them for the financial statements of the company, or more pertinently, just the most up-to-date management accounts, the most recent management accounts that they have. We go through those management accounts. we kind of corroborate what the directors have told us with what's in the management accounts, and we build a picture in our minds as to the situation that's at hand, and the reasons for distress, and the real reasons for distress, and whether and the extent to which it can be fixed. We then kind of develop a prognosis under each, for the recovery of the company, or the wind down of the company, as the case may be. Obviously, our purpose and our aim is to recover every company that's possible to a solvent going concern, but we need to be very pragmatic in our approach. So the next stage is for us to work out whether we can turn the company around without it going into business rescue, whether we can enter a compromise with creditors in terms of Chapter 6 of the Companies Act, whether it needs to go into business rescue, whether it's just business as usual with a little bit of intervention from our side, or in the worst case scenario, whether it's a liquidation. Now, very, very, very seldom will we identify it as being a liquidation straight from the outset, but there have been a select few occasions where we've just realized that the company's an absolute no-hope, and there are a couple of certain powers that a liquidator has that a business rescue practitioner doesn't have, and in those cases we've kind of encouraged the directors to liquidate, but those cases are very few and far between. And then once we've made a decision as to the way forward, or it's the best way forward, and it's very important to make the right decision at this stage, and then we'll discuss it with the directors and we'll proceed down that route. Typically, it will be as with COBRA. It will not be business rescue that we choose immediately. We much prefer to try and rescue the company under an informal turnaround scenario. In other words, a business rescue, but without the immediate legal protection of the Companies Act.
Questions have arisen in the last 3 weeks in relation to what do you guys do when you come in? You sit down with the directors and they say, look, we have a problem here. We've been under declaring our income, and there's a potential SARS liability, so they've come clean with you, but now they're not quite sure whether they should come clean with you. Do you have any comments on that?
Well, yes, look, we always do encourage the directors to come clean with us. It's very important that they tell us everything, and because that helps us to build an accurate picture as to what's going on, to identify the real causes of distress, and to find out where their minds are really at. As officers of the court, as Peter pointed out, we are duty bound to report any irregularities to the relevant authorities, any irregularities that we find. Obviously, if the directors tell us that there's an irregularity, then we need to report it. If we remember, we're not auditors, so we're not there to actually look for irregularities. But if we do come across an irregularity, or if the directors tell us that they've committed an irregularity with respect to SARS, for instance, then we are duty bound to report it to the relevant authority, which in this case would be SARS. So what we would typically do in a scenario like this, and SARS really encourages these voluntary disclosures, that we would go to SARS if it's in a business rescue scenario. Remember, prior to a business rescue scenario, it's the director's duty to report it, or anyway, we are not duty bound as business rescue practitioners because the company is not in business rescue. So if it's a business rescue scenario, we would approach SARS. We would explain to them the extent of the under declaration, and it's very important to note now at this stage, SARS is not there to close businesses down. They're not there. They understand, and I'm talking completely practically. SARS knows that there's a lot of people dodging taxes out there. So what we would do is we would explain to SARS what the situation is. We would explain to them that the company is in business rescue, and that the under declaration of tax would form part of SARS's claim as at the beginning of business rescue. What then would happen in terms of the business rescue plan is that inevitably all creditors end up taking a haircut, or their claims get reduced as part of the business rescue plan. So what we would try to do then is to reduce the SARS claim under business rescue. Obviously, in extensive negotiation with SARS, we would try and reduce SARS's claim so that the company isn't worse off in business rescue. The company isn't having to pay a higher amount of tax than they would if we hadn't come along. So us coming along and doing the right thing most of the time will not result in the company paying more tax at the end of the day.
Great, thanks. We have a question here which I'll deal with now. When you contact creditors to propose payment arrangements in order to avoid business rescue, is there a specific process and format for the communication one must follow? So the way it works is you first jump into the COBRA ecosystem. You do that by sending an email to info@cobra.org.za. You'll then get a response. It gets into a system. And what we do is we have a draft letter that you send to your creditors. It says in the letter that you've joined the ecosystem and that you invite them to simply join the ecosystem in order to negotiate those arrangements. So yes, there is a process. Once you hop in, the letters go out, we bring the creditors in, we then deal with their creditors, and the process begins. I think it's important to mention that we, as yet, I don't know if you guys can comment, have we come across an unreasonable creditor? I mean, most of them have been reasonable.
Yeah, most of them have. Maurice, I think everyone's just trying to digest what's going on at this stage of the game. You know, everybody, landlords, banks, everybody has been reasonable right now, you know. But, you know, as time goes by, everybody's just trying to find their feet. The reasonableness of a creditor depends on the extent to which their creditors in terms of being reasonable with them. And as time goes by, as the crisis evolves, as different companies become financially distressed, you might find that changing. You know, it's at some stage, creditors are going to have to start enforcing debt, and there will obviously be debtors, in other words, distressed companies that may not even be distressed and might end up taking advantage of the situation. So there's going to be, I think, conflict is going to arise in due course, and yeah, it's the uncertainty is just huge, and it's just likely to perpetuate, you know, and get more. So in time, yeah, in time, I suspect creditors will become unreasonable, if you like to call it that. Not all of them, but some of them will definitely start having to put pressure on their debtors. Then,
yeah, it's going to be very interesting. I've scenario planned in my head how this is going to possibly play out, because there's going to, in my mind, my thinking at the moment is there's going to be massive forgiveness across the board. And then ultimately, you know, if you think about it, it's landlords who are putting pressure, and why they're putting pressure downwards because of the banks, and the banks are putting pressure because of government. The government's going to ease the liquidity requirements, and I think it's just going to be between the banks and government.
I think it has to stop somewhere, you know what I mean? And government's not really in a position to grant massive relief or massive forgiveness. You know, if it's America, it's a different story, because they've got trillions of dollars of reserves, and our government clearly doesn't have that. The reason they're not bailing out SAA is not because they don't want to, and not because they don't believe in the business rescue process. It's because they simply don't have the money. So, so that's the problem. If there is massive forgiveness and massive relief granted, then at the end of the day, you can only assume that the economy is going to shrink substantially as a result of it. Peter, I don't know if you've got anything to add.
Yeah, just one thing that I think, you know, apropos of the question, is that one thing that we do need to be careful of is that because of, and we're all talking about the uncertainty, because of that uncertainty, a lot of people in small businesses are running scared at the moment, and landlords, I'm afraid, have been guilty of this, where landlords, you know, there's the concession of a deferment of rental, or a cutback in rental, as proposed by SAPOA, etc., where landlords have come forward and said, okay, we'll give you deferment, but you've got to pay us interest on the deferment whilst it's not paid. Now, that's not in terms of what's been agreed with SAPOA. So I think it is important that if people, even if they just have a question of that nature, to jump into COBRA to clarify what the actual position is, because people are confused, including as far up as the banks. There's been so many, you know, notifications from government and industry as to what assistance is out there, and not everybody's fully aware of what they can do and can't do. So I think people do need guidance on these particular points.
Yeah, it'll be interesting to see. We have another question. Morning, is a BR practitioner appointed by resolution or by court CRPC? And then a second to that, how is a BR practitioner an officer of the court? The BR practitioner can be appointed by resolution or by court. The resolution is a resolution by directors, not shareholders, and it's a 51%. Now, what's interesting about the resolution is that the company, in fact, is obliged to put business rescue to the vote in the event of the company being financially distressed. Now, bear in mind, a company being financially distressed is a low threshold. It means that there's a likelihood that you won't be able to pay your debts in the ensuing 6 months. So most companies are in financial distress and they've got to put business rescue to the vote. If, however, they vote against business rescue, there's an obligation in terms of the Act to notify all creditors and employees that the business rescue was put to a vote and it was decided or was voted against, and you set out the reasons as to why it was voted against. And a good reason in the present climate is to say that you jumped into COBRA, and COBRA is all about avoiding a business rescue, and COBRA has a methodology to avoid the company going into business rescue. Now, obviously, you want to avoid business rescue. There's also the question of the stigma. The stigma is, rest assured, nowhere close to where it used to be because of the no fault-based element to the predicament that businesses find themselves in. The court application is normally by a creditor or a shareholder who's aggrieved, who feels that the company should go into business rescue, but the directors are refusing to vote. So it goes to court on that basis. Another way it can be dealt with in court is if an application for the liquidation of the company, you can counter apply to rather have it in business rescue as opposed to liquidation. When you do that, you have to present a plan to the court. In relation to your second question, how is a BR practitioner an officer of the court? I'll take you to the section. You'll see it there. So this is section 140, general powers and duties of practitioners. And you'll see sub 3, during a business rescue proceeding, the practitioner is an officer of the court and must report to the court in accordance with any applicable rules of court orders by the court and has responsibilities. Peter, can you talk to this section whilst I'm on it?
Yeah, sure, Marisa. I mean, it's an interesting point. Of course, people tend to forget that CRPC is mandated by the law to administer the whole environment of business rescue. So as we are required to do reporting to CRPC in the various formats that reporting has to take place at the commencement and during the process of the rescue, the practitioner is by default then reporting to the courts. There is further obligations to report directly to the courts if it is a court appointment. But yeah, generally in any rescue, the mere reporting issues to CRPC is in effect reporting through to the courts as an officer of the court.
Maybe I could just add to Ray.
Sorry, the other point, just Maurice, on the court applications, the one we mustn't forget is that labour unions also have the right to, all staff, if they form an informal body, can approach court. But if we know, SA Express was a union application and SAA were on the verge of having a union application by Solidarity to place SAA into business rescue. So the unions can be quite powerful. They have stepped forward on a number of liquidation applications to have the application turned over into a business rescue. So the unfortunate thing with those is very often the union's not that close to the affairs of the company and obviously are focusing on their main point, which is to save jobs. But the unions do have the power to do that.
Yeah, whilst you're on employees, you'll see we've got section 144 up on the screen, rights of employees. And the point to be made there the take home for the audience is that the employees have the same rights that they enjoyed prior to the business rescue, and then they're afforded additional rights in terms of the section, for instance, to apply to court. So when it comes to dealing with your employees, it's very important to realize that you can't just unilaterally change their employment terms. You still have to consult with them in terms of Section 189 of the Labour Relations Act. And what Section 189 does is it deals with the process to dismiss employees based on operational requirements. The process requires that you give notice for the reasons, ways that have been considered to avoid the dismissals, and there's a list there. Now, the consultative process will be curtailed in these circumstances. I mean, you don't have to dig deep into why the dismissals are being proposed, but you have to go through the process. And if you want to vary the employment terms, you still have to go through the same process. But then you say, look, as an alternative to dismissal, and you're required by law to consult on that, you offer as an alternative a variation to the employment contract, such as a reduced salary. If, however, they refuse to agree to that, then you've got to go retrenchment, and you have to pay the severance pay. Severance pay is calculated as per the policy. If you have a policy, if there is no policy, it's 1 week per completed year. When it comes to methods of selection of employees, you've got to be reasonable, but you've got to try and agree with the employees. It's commonly referred to as a joint consensus seeking exercise. Whilst we're on employees, Ian, we have had instances where shareholders have been desperate to assist the employees, and kudos to them. And what they've done is they've decided to put money into the business by way of a loan, shareholder loan account, and they settle the bill, but this is pre-rescue. Do you have anything to say around that?
Yes, absolutely, Maurice. If a company is going to go into business rescue, or if it's likely that the company is going to go into business rescue, then it's better for the shareholder, if possible, to wait until it's in business rescue before they put money into the company. Whether that money is going to the company to pay employees or pay rent or whatever the case may be. The reason for that is because once the money goes into the company after business rescue has commenced, that money is known as post-commencement finance. And post-commencement finance, when it comes to repayment of those debts, enjoys seniority over the repayments of other debts. So whilst in business rescue, that debt will rank right at the top of what we call the waterfall when it comes to repaying those debts. So if the company is in business rescue and it's in a position to repay debt, it'll repay the holder of post-commencement finance first. If the company subsequently, heaven forbid, goes into liquidation, then if the post-commencement finance that was put into the business is secured by an asset in the company, then once in liquidation, that will rank right at the top, immediately below liquidator's costs in terms of repayment. So secured post-commencement finance, should a company go into liquidation, ranks right at the top of the waterfall. Unsecured post-commencement finance, unfortunately, in liquidation drops down substantially down the waterfall, as does the business rescue practitioner's fees and remuneration. So if possible, if you're going to put money into the company, put it in after the company has gone into business rescue, and try to secure it by means of an attachment to an asset in the company.
Right. Thanks for that. Just on the question of finance, I think it's also important to mention that many of our consortium partners are in the business of providing finance. I mean, you'll see RMB is somewhere. When it comes to businesses requiring finance, because the PCF, the post-commencement finance, gives you what's referred to as super preference, there is an appetite to give that finance, particularly if it's only commercial solvency that's an issue, not factual solvency. The distinction is the one, commercial solvency is you cannot pay your debts as and when they fall due, whereas factual insolvency is your assets, your liabilities exceed your assets. So that results in commercial and no asset value give rise to liquidation or grounds for liquidation. I just want to go back to you saying what do you do when, I asked you the question, what happens when you're appointed as business rescue practitioner? And something I don't think you dealt with, and that is it's really important when it comes to the moratorium to appreciate that the moratorium does not necessarily apply in certain circumstances. And one important circumstance, and this is another very important taker, is where there are agreements that have not been suspended by the business rescue practitioner. So the first thing the business rescue practitioner must do upon his appointment is suspend those contracts, the most important being the lease agreement. Because if the lease agreement is not suspended and the lease agreement is subsequently cancelled whilst the company is in business rescue, then an eviction is appropriate. Judge Barachowitz held as much, so that is the state of the law. So if you're going to be outside of COBRA and you're not going to be coming into the COBRA environment, let's say a business rescue practitioner, ready to first question the business rescue practitioner on whether they're aware of this, and secondly, give the business rescue practitioner a list of all your creditors, all the counterparties to the contracts, and the details so the business rescue practitioner can immediately suspend those contracts. Legal matter where the contracts were not, the lease was not suspended, the cancellation was then a race to get to the business rescue, put in a business rescue, suspend the agreements prior to the breach notice expiring. We've just did you go into much detail in relation to the voting?
No.
I'd like you just to go through, just take us through, Ian, the following scenario.
Mm.
You have a 100 Rand loan account.
Mm-hmm.
You have 50,000 Rands trade creditors. So the shareholders loan account, 1,050,000 Rand trade creditors, and you have a business plan to be voted on.
Mm-hmm.
The business, as a shareholder, you believe the business plan is absolute nonsense,
Mm-hmm.
and it's going to lead to the destruction of the company. You have the £1 million loan, the creditors have a 50,000 Rand loan. What happens?
So the vote required to pass a business rescue plan is 75% of all creditors, be it in person or by proxy, who vote, and the 75% is measured by value. So that is the first requirement for it to be passed. And out of those 75%, 50% of the creditors who vote must be independent creditors, in other words, trade creditors. So in this situation, you would require the shareholders, it would require the shareholders' positive vote in order for the business rescue plan to pass. So because the shareholder is by far the biggest creditor, and out of a total of 1,050,000 creditors, the shareholders holds a vote of 1 million Rand. So he's obviously going to be there to vote. He's having received appropriate notification of the meeting. He's not going to miss the opportunity to vote. So it would require his vote in order for the plan to be passed. If the trade creditors like the plan and they pass it and they vote in favor of it, or it only requires half of their vote, provided they're all independent trade creditors, then that doesn't really matter. The fact that the shareholder did not vote in favor of it would mean that the business rescue practitioner would need to amend the plan to the extent necessary in order for the shareholder to be satisfied with it. The requirement is 75% of all creditors who vote, whether it be they independent or be they non-independent shareholders.
Great. Whilst you're on the plan, Ian, can you take us through how practically a plan works? So what do you guys do to get the plan right? And whilst you're dealing with it, deal with directors and how they get involved.
Absolutely. And Peter, feel free to jump in if I'm missing anything. But okay, so let's just deal with directors first quickly. In business rescue, the directors have to, they carry on with their normal duties and responsibilities, but the directors now have to report to the business rescue practitioner. The business rescue practitioner has ultimate control over the board of directors, however big the company may be. So hence the choice of business rescue practitioner for the directors is very, very important, because at the end of the day, it's his decision whether to ratify any decision that's made by the board. So very important to find the right business rescue practitioner who will walk with you, will hold your hand through the process, who won't think that he knows more than he does know, who won't kick the CEO out of his seat and think that he can run the company and take over the relationships that the CEO and the board has built up over the last 20 years or whatever the case may be. So choice of business rescue practitioner is critical. The role of the directors, they carry on with their normal business but report to the business rescue practitioner. The business rescue plan itself is basically what the business rescue practitioner needs to put it together within 25 days of being appointed. That time frame can be extended, as in the case of SAA, as in the case of a lot of big business rescues. In the small to medium-sized business rescues, we can normally get those plans out within the 25 days, and we always try to get them out within the 25 days because it shows us the creditors that we're serious about what we're doing. So what is contained in a business rescue plan is everything that would be contained in a business plan that would present to the bank. In addition to that, it's got breakdowns of creditors classes, breakdowns of assets and asset classes and so on. And very importantly, what is in a business rescue plan is a comparison of what the company would get in liquidation versus what the business rescue practitioner envisages it would get in business rescue. So as Peter pointed out correctly earlier, the liquidation dividend is normally quite a low benchmark. And in a business rescue plan, we would aim to, and we do normally show a substantially higher dividend to creditors than the company would get in a liquidation scenario. So yes, and another very important part of the business rescue plan is the 3-year financial projection. So business rescue practitioner has to take what he understands of the business, what he understands of the distress, what he understands of how his plan is going to address the distress, and he needs to put that into financial forecasts for the next 3 years. Those financial forecasts can be done by month or they can be done by year, but it needs to be his best estimation of how the financials are going to pan out for the next 3 years. Yeah, and that's basically what goes into a business rescue plan. There's quite a bit of detail. It's covered under Section 150 of the Companies Act, and the business rescue plan is really what it's all about. Once the business rescue plan is published, 25 days after the business rescue practitioner's appointment, then 10 days after that, the business rescue practitioner holds what we call the second meeting of creditors. All the creditors get together, having had 10 days to consider the plan, and that's when they vote on the plan, whether to adopt it or whether to reject it.
Yeah, a restaurant in Camps Bay, and there it was negotiating with the landlord. Landlord agreed, so it was business rescue in. Agree with the landlord, very simple plan, gets voted. It was an in and out, and can be simple. But whilst I've got you in, there's an alternative. That's Section 155 of the Companies Act. So you don't necessarily have to go the business rescue route. There's another statutory route that you can look at, and that you do look at.
Yes, Maurice. Section 155 compromise is typically when we think there's a quick resolution, like the case that you just explained, where something can quickly be resolved and the creditors are really relatively friendly and easy to negotiate with. In other words, there's no really aggressive creditors banging the door down. Then we would often look at going the Section 155 compromise route. what that basically involves is us putting together a plan, working out the extent to which each creditor in each class needs to take a haircut, or by the extent to which their claim needs to be reduced in order for the company to become solvent and then move forward on a going concern basis. So what the Section 155 compromise requires is in each class of creditors, so you'd have your secured creditors, you'd have your preferent creditors being SARS, being employees, and you'd have your concurrent creditors being your normal trade creditors. Each class has to vote in favor of the plan, and it's a 75% vote in each class that is required in order for the Section 155 compromise to be passed. So the practitioner would get all the creditors together, they'd agree, and then once everybody's agreed, then the compromise, the practitioner goes to court and he gets the compromise made in order of the court. The moment it's made in order of the court, all the creditors have taken, then the haircut that they're taking is official and the company can carry on as normal. The disadvantage of the Section 155 compromise is if you've got aggressive creditors who are banging the door down, they may be then in a position to liquidate the company or to attach assets or to get judgments against the company and attach assets whilst the business rescue or whilst the turnaround practitioner is still negotiating the Section 155 compromise plan. So that's the only disadvantage of the Section 155 compromise, but it is a very nice tool for us to have to consider out of the 5 or 6 or 7 options that there are at the beginning of a turnaround.
Sure. Peter, the question hasn't been asked, and it often is. Please pose questions, because it begs the question, why was this not questioned? Why was it not raised? Sureties. Peter, what is the effect of business rescue on a surety? Because now we have a moratorium and all claims are suspended. But Peter?
Maurice, we lost you there. We lost you for a second.
I think I got the gist of it, Maurice.
Okay.
Sureties, it's a very important question. It's one we always ask where we are faced with generally small to medium-sized companies. Have the directors and or shareholders sign suretyships on behalf of the company? Something that often in a medium to smaller company people forget. They normally think the bank is the person holding the security, but you very often find personal sureties have been given in terms of asset financing or lease agreements or operating leases, etc. So it is an important question. The suretyship is not affected by the rescue. It still stands. It itself is not frozen, so the protection to the company doesn't extend as far as the directors and shareholders who have signed sureties, generally classed as personal guarantees. And the important thing there is for the practitioner to very quickly understand the wording of the surety, because if the surety allows the lender the right to pursue his rights against the individual, irrespective of the company, and the company obviously by going into business rescue has generally made a declaration of default under most loan agreements. And in that case, the bank can go against the individual for payment. That is a bit of a chicken and egg, because the bank can only pursue the principal that's still outstanding. And obviously, if there's a business rescue plan that claims that part of the debt is going to be funded through the plan, possibly 100% or a compromise, then it's important for the practitioner to negotiate with the holder of the security to make sure that they abide and don't go after the personal suretyship. On the other hand, there could be a case where, in order for the company to survive, the personal suretyship has to be pursued because it relieves the company of the obligation. So it might be a bit of a matter of life and death, but it is a negotiating point, and it is a balancing act that's got to be found between shareholders' obligation and or directors' obligations versus those of the company.
Thanks, Peter. Can we deal with the skills of business rescue practitioners? What are the requirements for a business rescue practitioner to be appointed? What are the qualifications that are required? And just how does that feature when it comes to business rescue versus, let's say, liquidation?
Absolutely, Maurice. So the skills that are required for a business rescue practitioner to be registered with the CIPC, either he has to be an attorney, or he has to be an accountant, and a member of one of the professional bodies, or he has to be a business management consultant, and a member of a professional body. So that's what CIPC requires for a business rescue practitioner to be licensed with them. In practice, the skills that are required by a business rescue practitioner are so much more than just being an accountant or an attorney. And we often rattle off these skills that we believe are required. And it's very difficult to almost impossible for one person to have all the skills that are required. Thus, your best turnaround firms are the ones that have a number of individuals at the core, with all the core sort of turnaround skills. And we believe those skills to be leadership skills, entrepreneurial skills and experience, strategic skills, financial skills, legal skills, operational skills, deal structuring skills, and capital raising skills. Now, having rattled those off, I'm sure everybody will agree that it's almost impossible for one person to have all of those. So at Engage and at COBRA, we have at our core several very senior staff or team members who amongst them we believe have those skills. And then between us, we obviously have a very strong network from which we can draw specialist skills in specific industries when we get involved in specific industries. So our team brings the core skills, the core turnaround skills, and then from our trusted networks, and it's very important for me to use the word trust, from our trusted networks, we can draw the skills of trusted individuals in specific industries that we get involved in. And those networks span across almost every industry in the country. So we're therefore able to assist in virtually any company that comes our way. How the business rescue practitioner's skills differentiate or differ from a liquidator's skills. Liquidator's skills are really around the Insolvency Act and around being able to realize assets to the best extent possible. I'm sure there are other skills, but the skill set differs substantially from that of a business rescue practitioner. Liquidators are allowed to act as business rescue practitioners, not in the same matter. So somebody can't be a business rescue practitioner, and then if the company goes into liquidation, they'd be the liquidator of the same company. But liquidators there are a number of liquidators operating as working as business rescue practitioners. A lot of let me just say this. We're not here to knock liquidators by any means, but liquidators don't like business rescue practitioners for a couple of reasons. The main reason being that they feel that the business rescue practitioners get hold of the assets of the company before the company inevitably goes into liquidation. And thus the liquidator at the end of the day is deprived of fees because the business rescue practitioner would have sold assets under business rescue and presumably earned fees from that. So there is quite a lot of tension between business rescue practitioners and liquidators to that extent. Now a lot of liquidators have overcome that is by becoming business rescue practitioners themselves. So yeah, it's quite an interesting scenario, quite an interesting dynamic there.
Thanks, yeah, and I want to emphasize, just look at the partners in relation to COBRA. I've known IQ Business for 22 years since they started. I think it was around about 97, 98. And IQ Business have been dealing with blue chip companies and been assisting blue chip companies in relation to their strategies, in relation to their growth. So, it's really, the skill set goes from blue chip all the way down to SMEs. And I think that's invaluable to COBRA. And one must be mindful that these skills are available on a pro bono basis. The COBRA, the entire initiative is predicated on being able to assist companies who cannot afford that assistance. So there is a means test in relation to what is required for you to get all this assistance at no cost. If you pass the means test, if you're really in a dire, factually insolvent situation, everything comes at no charge. So much so that if a liquidation doesn't work, and I'll ask Peter just to deal with those circumstances next, but if a liquidation doesn't work, a business rescue rather does not work, then a liquidation is necessary. And if a liquidation is necessary, a high court application becomes necessary, and that high court application costs between 30 and 50,000 rands. That high court application will be attended to by COBRA. It will be Schindler's attorneys as a partner who will attend it to at no cost to the business, which in our mind is quite important, because that's one hell of a knock to take at a point in time when you've lost your business, your means to earn an income. So Peter, just on that score, just the business rescue plan and a liquidation, and let's say a business rescue plan is passed, but the implementation fails. What then?
Maurice, yes, look, obviously one of the critical things in the business rescue plan is flexibility, because bearing in mind it's business as usual. You're trying to operate a business. It's not just a wind down situation. So obviously, because it's looking into the future, and as we all know, people who are running their own businesses, the one thing that we know for certain is that any business rescue plan or any business plan generally is inaccurate on the day it was written, because we don't know what the future is going to hold, irrespective of a virus coming out of left field. But if it doesn't work, and it's interesting how far one pushes this, because sometimes it feels it's not working, but if you apply your mind and be a little bit creative, and if there's a major change to the original plan, get the creditors to approve an amendment to the plan, the practitioner has the ability to do that. But in the circumstances where all fails, and these do happen, bearing in mind the business practitioner, if he's completely unknown to the company prior to his appointment, has got literally 3 days to make his decision whether he feels this can be rescued or not. So you're wading through financial information which may not be 100% accurate, may not be 100% up to date, and you take a decision, and then you find that what you were handed in reality is very different from what you thought you were being handed. And in that scenario, or a scenario where you believe that you can continue trading and something comes that affects the business, such as a virus, then you might find that the best option is to go into liquidation. Now, the thing with liquidation is the business rescue practitioner has to, at every step of the way, make a formal statement on a monthly basis, if he's giving a monthly report to the creditors, and certainly in the plan itself, that the practitioner, he or she firmly believes that the company can do better in business rescue than in liquidation. And what that means is that the creditors are going to earn more out of a business rescue dividend than they will out of a liquidation dividend. But at a point comes where he cannot state that categorically any longer. He can then unilaterally, he must unilaterally put the business into liquidation. That means no support from the directors for the liquidation or the creditors. What Ian and I normally do is put it to a creditor vote to get support for the liquidation, just to make sure we're all on the same page. And then, and this is where, Maurice, you make the point, and a lot of practitioners who are dealing in the smaller end of the market have been caught short on this. The practitioner himself can end up having to fund the legal costs of putting the company into liquidation if there are no other funds available, because he's obligated to do so. And then it's a matter of, as Ian said, the practitioner himself cannot be the liquidator, rightly so. And then it's a matter of then doing the application to court, and hopefully it's not opposed, and the company goes into liquidation, and then the liquidator takes over. And this is what Ian was touching on a second ago, that liquidators get a bit aggrieved if you've tried to rescue it and assets have diminished during the rescue, that they handed a company with less assets to apply to use in the liquidation.
Thanks, Peter. I just want to say to the audience, we only got a couple of minutes left, so please think about your questions and pose them so we can deal with them. Peter, whilst I have you on, What happens if, talking about liquidators and business rescue practitioners and the reputation they have, what happens if you as a director find that the business rescue practitioner is incompetent or dishonest? What relief? What can the directors do?
The courts provide relief. Bear in mind, as Ian said, the practitioner has to be qualified, firstly, and that's a member in good standing of a professional body. Must be competent, must be independent, so cannot have had your auditor cannot be your business rescue practitioner. Has to be independent and has to apply remember he's basically, in terms of the act, picking up the same fiduciary duties as a director has. So if he's been dishonest, fraudulent, underhand, unusual, but if that is the case, then the directors can apply to court to have him removed. But more importantly, if he's just completely incompetent, and unfortunately, like with any profession in life, there are practitioners who are fairly incompetent and is not doing very much to protect the creditor's interests and rescue the business, and just sitting back thinking he's earning a monthly annuity, then the directors can apply to court to have him removed on the basis that he isn't complying with the law and not performing as he's supposed to perform in terms of Chapter 6, and have him removed. The challenge, well, the interesting point there is if a practitioner is removed, the important thing is the applicant could be the creditors or the directors or a shareholder or a labor union, is to make sure that you've got a practitioner on hand who's been briefed and is prepared to take on what would maybe a fairly difficult situation, because maybe the practitioner has been doing his job properly. It's an untenable business situation. So if you've got a practitioner who's willing to step into the breach, is to present the practitioner's credentials to the courts. Failing that, the courts, through CRPC, will appoint a practitioner. And then, as Ian said, it's a little bit into the unknown. We have a practitioner who himself was at one point declared personally bankrupt, or had a personal bankruptcy charge against him. He's there to save businesses. He can't save himself, for goodness sake. I'm also aware of a ex-CEO of a company that was involved in fraud, who ended up paying a fairly significant fine to the FSB, or the FSCA as it is now, and he's a senior business rescue practitioner. So, and those have arisen because CIPC is responsible for registering and licensing practitioners, and unfortunately, in the early days, they really didn't have the mechanisms to do that. They have now delegated that authority to professional bodies, as Ian said, Law Society, South African Institute of Accountants, the Turnaround Management Association, etc. There's a number of bodies that are now accredited to register, well, not register, but to allow people to join their societies, and CRPC does ask for full recognition of somebody that they're up to date and in good standing. So it's less likely to happen now, but it has happened before that some practitioners may well be a little bit underhand.
Thanks. Ian, there's a question. Is there a standard tariff of fees that a BR practitioner must abide by?
Yes, there is. Chapter 6 of the Companies Act does prescribe certain fees. It ranges from 1,250 Rand an hour, including VAT, up to 2,500 Rand an hour, including VAT. We generally perceive those fees to be outdated. The Act having been written in 2008. Having said that, our fees as Engaged and COBRA are, and Schindler's in this case, are geared completely towards what the distressed company can actually afford. So that is the first thing that we consider. However, when we're dealing with a sort of medium to large size company that does have sufficient cash resources to be able to pay our fees, what we typically then do is we structure a fee that we believe is reasonable. Our charge out rates are normally in the region of about 3,000 Rand an hour. And what we would do is we would put it forward to the creditors of the company to vote on our fees, should they be higher than the prescribed tariffs. So yes, that's what we normally do. And then also in the case of a medium to large company, we typically charge contingency fees as well, and contingency fees are payable at certain milestones of the implementation of the business rescue plan having been achieved, or at the end of the business rescue plan. But it's very important to note that the contingency fees that we charge are always linked to real success in terms of turnaround. There have been instances in the past, and it's almost become an acceptable practice for business rescue practitioners to charge a contingency fee once the business rescue plan is approved by creditors. And we don't consider that to be correct at all, because the approval of the business rescue plan is not a milestone in the turnaround, in the implementation of the business rescue plan. And in fact, the approval of the business, charging fees, contingency fees upon approval of the business rescue plan, in fact gives rise to a conflict for the business rescue practitioner, because he's more likely then to cave into the demands of creditors in order to get the business rescue plan approved. And him caving into those demands of the creditors is likely to impact his ability or impair his ability to then implement the plan properly and effectively to make the business rescue actually work. So yes, if we charge contingency fees, it's very much about charging those fees, linking those contingency fees directly to actual turnaround success.
100%. Okay, well, that concludes today. I just want to wrap up by mentioning that business rescue, the provisions that we've discussed today do not apply to sole proprietorships, to trusts, or to partnerships, but they do apply to closed corporations. If you have any further questions, we're quite happy to set up private Zoom meetings with you and your team as part of the pro bono service, regardless of whether you pass the means test or not. There's quite a pool of resources. There's a knowledge base on our website, www.cobra.org.za. If you want to enter the system, it's info at sorry, I was distracted by a comment. It's our pleasure, Rachel. Yeah, so reach out. Let's have these meetings or contact us. You can contact us directly as well. Thank you very much. Thanks to the panelists. We'll see everybody on Monday.
Thank you.